Good evening, participants. I, Chaitanya Bansal, on behalf of Team Corporate Law Advisor and CII, welcome you all to the first session of our live channel on ADR laws. Under this unique concept, you will be provided with all the updates taking place throughout the year 2021 in the field of laws relating to ADR, and an in depth analysis will also be conducted on topics of importance. The sessions shall be moderated by Vishwam Jindal sir, and the analysis shall be taken by panel of experts. Vishwam Jindal sir is an advocate practicing in litigation, arbitration, online dispute resolution, and he is also the chief anchor of all these sessions. So with these words, I now hand over the dice to Vishwam sir. Thank you.
Thank you very much, Chaitanya. And thank you to CII, the Confederation of Indian Industries, and CLA Corporate Law Advisor. I'm just going to share my screen now, and then I think we can take it forward from there. Are you able to see my screen?
Yes.
Okay, perfect. So this is the agenda for today. I'll start with sort of brief introductions to the panelists. Chaitanya has very kindly given an introduction about me. After that, what we will do in this entire ADR channel series across the board is we will divide it in sort of three broad categories. The first category would be updates. Like Chaitanya mentioned, we would be covering sort of leading decisions of the Supreme Court, High Court, and even global decisions from, say, the English High Court or courts in Singapore, or arbitration decisions which have an impact on how arbitration, mediation, conciliation, and online dispute resolution in India takes place and affects businesses. This will be the sort of first part. In the second part, we will have a training and knowledge session in each webinar. So for instance, today we're going to discuss how businesses should draft jurisdiction clauses in their contracts, whether you should pick an arbitration clause, whether you should confer jurisdiction on courts, whether there should be an exclusive jurisdiction clause, etc., and how that fits in with a governing law clause in a contract. Along with these two sessions on updates and training knowledge session, we'll have a panel discussion. Every month, there will be a different panel, which is based on the topics that we're covering and their expertise. And then finally, we will have sort of question and answers in the end, but during the session as well. So if I'm going through any case law or any update or any knowledge session, if you have any question, please feel free to sort of put that in the message box, or feel free to unmute yourself and ask the question, and then we can deal with it there. If there are a lot of questions that you have, I would prefer that we deal with it as and when we go, rather than you wait till the end to ask that question, because a lot of other people may also have the same question. So it's probably going to be helpful if we're covering a topic, then we just deal with it there and then. Okay, great. So moving on to our first sort of broad chapter of updates, we're essentially looking at three key decisions which have taken place in the past few months. We look at two decisions of the Delhi High Court. The first one is the Future Retail Limited versus Amazon. It's been in the news for a while now. Is essentially relating to emergency arbitrator. The second one is Vidya Drolia versus Durga trading. In this case, we'll be discussing about arbitrality of what is arbitrable and what is not arbitrable, and I'll come to what that means. And the last one, we'll basically be discussing if two Indian parties can pick a law which is outside India. So you can pick the English law, or you can pick Singapore law, for instance, to apply to your contract. We'll also discuss some updates on online dispute resolution and mediation. Okay, so I'll move on to the first one. So this is, I won't go in too much into details on what the dispute was. And essentially, there were a number of issues in the Delhi High Court suit that was filed. Essentially, what we're concerned about is only one issue, which principally relates to the Arbitration and Conciliation Act, and that deals with emergency arbitrators. So the number of issues, very quickly on the factual background, essentially, Amazon had bought certain shares into one of the Future Group entities. Shares of a different Future Group entity were being sold to Reliance, And then there was a dispute among various shareholder agreements between Amazon, Future Group, and the sale to Reliance for Future Group shares. So basically, there was an arbitration clause which provided for SIAC arbitration, Singapore International Arbitration Center, seated in New Delhi. It was an international commercial arbitration. What happened was that the parties applied to SIAC to form an expedited or emergency arbitration tribunal comprising a sole arbitrator. I'll come to that, how that works, but essentially that arbitrator gave a decision which was challenged before the suit in the Delhi High Court. The merits of the award was not challenged, but the fact that whether the emergency arbitrator can be recognized or can be appointed in arbitration seated in India was essentially the main sort of challenge here. If I'm using some terms like emergency arbitrator and you're not familiar with them or you want me to explain them, please sort of let me know in the chat box or just unmute yourself and shout, and then sort of we can deal with those concepts there. For the purposes of this session and sessions generally this year, I'm assuming that most of you are familiar with how arbitration, mediation, conciliation works, and that you're familiar with sort of certain basic terminology. Thank you. So the principal issue that we're looking at here is if awards passed by emergency arbitrators are recognized under Part 1. So as you know, Part 1 deals with sort of arbitrations seated in India, and Part 2 deals with sort of international arbitrations generally seated outside India. So what happened here was that the arbitration clause, which I will actually show you in due course, said that the arbitration will be governed by SIAC rules, seated in New Delhi, 3 arbitrators, and Indian law was to apply to the contract. As I said, SIAC appointed an emergency arbitrator, and the emergency arbitrator gave an award. This was challenged by Future Group and Reliance, and they said that the order passed by the emergency arbitrator is not recognized under Part 1. In fact, emergency arbitrators lack legal status, and they're basically quorum non juris, which basically means that an emergency arbitrator is not a judge. So there were, like you can see, there were 6 submissions that Amazon made, essentially saying why emergency arbitrators are recognized, and there's no problem with having an emergency arbitrator under the Act. The first one was to say that it's compatible with Part 1 of the Act. Now, Part 1 of the Act allows parties to agree procedural rules. And in the present case, as per their shareholders, the parties have basically picked SIAC rules. When we come to the knowledge session today, I'll discuss in detail on how there are various governing laws to a contract and how different laws govern different elements of the contract, of the arbitration agreement, and the QE law, which applies to the arbitration when it's conducted. But essentially, the submission of Amazon was that arbitration is all about party autonomy. And if that's true, then parties picked the SIAC rules, exercising their autonomy, and SIAC rules do provide for emergency arbitrators. And accordingly, any decision or award rendered by the sole emergency arbitrator is valid and the High Court should not intervene. It also said that the termination of mandate and substitution of the arbitrator has been provided for under Section 15 of the Act. Now, one of the submissions made by Future Group, and maybe I'll move to the next slide on this, is that they said that you can't do that because essentially what happens when you appoint an emergency arbitrator is that the emergency arbitrator does not go into detail on the question. So essentially, if it was to be a 3-member tribunal, SIAC or any institution would appoint an emergency arbitrator. He would give his emergency award, and then his role is essentially finished. And 3 new members are appointed on the tribunal, which is essentially the final tribunal which is constituted. So Future Group said that that's not how Part 1 of the Act stipulates it to be, because if there is an arbitrator, there has to be some sort of permanence to that arbitrator. So essentially, they relied on Section 11, subclause 1 for this permanence, and said that that's basically against Part 1, which is why we don't recognize emergency arbitrators. However, Amazon was saying, that's not true because it's all based on party autonomy, and Section 15 does provide for termination of the mandate and substitution. Amazon also relied on certain other decisions, which you can see on the screen, to basically say that, an award the emergency arbitrator's decree and not base paper. Another important decision which came out of this, and generally the party submitted, was that if you have an emergency arbitrator, you're basically barring the jurisdiction of the courts under Section 9 to give interim relief, because the only remedy as per Future Group's submission to get interim relief before an arbitration tribunal is constituted is through courts under Section 9. Amazon, of course, said that's not true because Section 9 is not a mandatory provision. So the parties can essentially contract out Section 9 if they want to. So these were the sort of main submissions made by both parties on this issue. And I'll tell you what the decision was. So basically, this is what the court held. And I'm just going to read these sort of very important paragraphs, and we can discuss them in detail. So I'll read it from the screen if you can read it. Where the parties exercising autonomy expressly choose different procedural rules for conduct of the arbitration, they are assumed to be aware of the provisions of such rules, including the procedure for obtaining interim relief, and the fact that such rules provide for emergency arbitration by appointment of an emergency arbitrator. In the present case, the parties had, with open eyes, left it for themselves to choose between availing interim relief from the emergency arbitrator on the one hand, or the courts under Section 9 of the Arbitration and Conciliation Act on the other hand. Thus, Amazon has exercised its choice of forum for interim relief as per the arbitration agreement between the parties. Nothing in the Arbitration and Conciliation Act prohibits the parties from doing so. So essentially, it's coming back to the point we were discussing earlier. One of the main things was whether Section 9 of the Arbitration and Conciliation Act, which says that you can go to court for interim relief, is that a mandatory provision that parties can contract out of or cannot contract out of? And the Delhi High Court said that it is not mandatory, so you very well can contract out of that. And this is essentially what happened when the parties picked SIAC rules, because SIAC rules provide for an emergency arbitrator. The other issue that sort of Future Group and Reliance raised was that the Law Commission had actually recommended to the Parliament to include emergency arbitrator within the definition of arbitral tribunal under Section 2, Clause 1, Clause D of the Act. But that was not done by the Parliament. The Delhi High Court, however, held that just because the Parliament didn't accept Law Commission's recommendation doesn't mean that an emergency arbitrator is not an arbitrator. So it said that it cannot be held that an emergency arbitrator is outside the scope of Section 2(1)(d) of the Act because the Parliament did not accept the recommendation of the Law Commission to amend Section 2(1)(d) of the Act to include an emergency arbitrator. And the next one you can see is just on Section 9. So the court basically held that it was perfectly legal for a different procedural law, which was SIAC rules, to apply. It also held that SIAC rule is not contrary to or repugnant with the public policy of India or with the mandatory requirements of procedure law under the Arbitration and Conciliation Act. I'll explain this in detail for those when we deal with the governing law clauses, for those who are not familiar with how different laws apply and intersect with each other when there is arbitration. I just want to come back to this very important paragraph which the Delhi High Court relied upon, and it's the decision of the English Court of Appeal from 1983 in the Bank Millet versus Helsinki Technique case, where again, looking at various laws that apply, it said procedural law of the place of arbitration and the courts of that place cannot be altogether excluded, particularly in respect of matters affecting public policy and other mandatory requirements of the legal system of that place. But in a proceeding such as the present, which is intended to be controlled by a set of contractual rules which are self-sufficient and designed to cover every step of the proceeding, the need to have recourse to the municipal system of law and courts of the place of arbitration is reduced to the minimum, and the courts of that place are unlikely to interfere with the arbitral proceedings except in cases which shook the judicial conscience. So that was essentially the decision in the Future Retail versus Amazon case. Are there any questions that anybody has before we sort of move on? I'm going to apologize for not introducing the panelists before, but I'm going to do it now when I ask them questions. So we've got Justice Rajiv Bhalla with us on the expert panel. He's a former judge of the Punjab and Haryana High Court, and he's currently a senior advocate practicing in the Delhi High Court and Supreme Court. Justice Bhalla, can you hear me? Justice Bhalla?
Can you repeat the question? I didn't get it.
Sorry, yeah. I was just asking if you can hear me because I couldn't see you. So do you have sort of any thoughts about this decision of emergency arbitrator by the Delhi High Court? Do you think it'll encourage arbitration and it'll encourage parties to have an appointment of an emergency arbitrator rather than actually going to courts under Section 9 for interim relief?
See, I personally feel after reading the judgment, this is para 17 is the judgment if anybody is interested. If you can share it with everybody, para 17. So there are a few ifs and buts in the exercise of this discretion if you look at it. We therefore hold that although an application under Section 9 is maintainable in connection with a foreign seated arbitration, an application thereunder would not lie after the constitution of the arbitral tribunal unless the applicant demonstrates that it does not have an efficacious remedy before the tribunal. Now, this is again, this is called that a circuitous relief. So you are sending one, you are trying to solve one issue by now creating another one. So every time somebody comes under Section 9 or he comes for this thing, he will first have to prove that the there was no efficacious remedy available before the arbitral tribunal. So in essence, I think this sentence is the death knell of this judgment itself. I'm sorry to be using this word, but maybe down the line after 2 years, somebody may again want to change this or alter this, because my experience in law is that once you start making exceptions to a provision, then those exceptions tend to get added on. Then somebody will say, yes, this is all right, but I think this should also have been done. So, well, the power is definitely there, read into it. The court is read into it. This is the law. But I believe there's an SLP pending also on this.
Yeah, I think so.
So before we give the final verdict, I think let's reserve our comments. But I think it's a good thing. It's a good initiative. But these ifs and buts one has to just look at. Because you'll be again left again, then somebody will say, then I'll again go back to the arbitral tribunal. Then the arbitral tribunal will again say, I don't have jurisdiction. It will come back to the court. Section 9, then we'll go and appeal. So what I'm trying to say is that apart from the law being uncertain or law adding confusion, sometimes even we tend to add a little bit of ifs and buts so as to make our judgment a little more, that, okay, fine, we've taken note of if I get a jab from the virus and if I get temperature, so I must give a tablet in advance. So if I'm going to get, these are, all judges have a habit of doing this. I mean, it's not, I'm not being the honorable judge, but what I'm saying is this if and but judgments will cause problems. This will cause a problem. Now, if they want to invoke this, they have to prove these. Para 17 is the one which I am looking at.
Yeah.
So that is what it is. It should either be a clear-cut jurisdiction or a no. Because we are dealing with arbitration. So the idea of arbitration is to cut short litigation.
Yeah.
This way we are just kicking the can down the road and then somebody will kick it up and somebody... This is how I look at it.
No, that's very helpful. I think we have a question from Mr. Rohan Sachdev.
Indeed.
Do you want to ask?
Yes, sir. Thank you for having me, sir, and good evening to everyone present. My question, sir, is it might be a basic question, but please do bear with me as I'm quite new to arbitration. So as I understand it, the rationale for having an emergency arbitrator, the concept of an emergency arbitrator is to ensure that the actual arbitration itself, whenever it may commence, is not rendered irrelevant. So for example, if there is a party trying to say move assets out of the country, the emergency arbitrator, if appointed, may pass an interim award to stop that, right? So in light of this, if we juxtapose this with future retail submissions and that there must be permanence to an arbitrator, I mean, how do we reconcile these two concepts?
No, I think you're absolutely right, Rohan. I'll probably give my thoughts and I'll open it to the panelists. But I think you're absolutely right. I think the essential function of the emergency arbitrator is to provide interim relief, similar to what the courts would do under Section 9, for instance, if a party to the arbitrator was to move his assets out of the jurisdiction or was to sell its assets or sort of move money into offshore jurisdiction where you possibly can't enforce an award or judgment against. I think it's sort of those sorts of urgent reliefs or interim measures, which essentially the emergency arbitrator is appointed for. It's also quite interesting because if you look at SIAC rules or any other rules, the emergency arbitrator's role is essentially just to give interim relief and then that's it. And then a fresh tribunal is constituted, whether it's a sole arbitrator or a 3-member tribunal, looking at all the issues afresh from fresh pair of eyes, looking at the arguments. And the arbitration tribunal, once constituted, can of course either agree with the emergency arbitrator's award or disagree with it and pass a completely new order in their final award then. So I think I absolutely agree with you. I think there has to be a balancing exercise, I guess, which arbitrators would do. I'll leave it open to the experts. Mr. Jindal, Justice Bhalla, did you have anything else to add?
Yes, I just want to add one thing. Once the Parliament, in their legislative competence and prudence, thought it not competent to provide for emergency panel of arbitrators. Instead, they have given this power to the courts under Section 9. It is something like a relay race. The baton is with the court first, and once an arbitral tribunal is in place, then that baton is handed over to that arbitral tribunal. Then arbitral tribunal is to decide that whether interim measures adopted by the court under Section 9 is to be continued during the pendency of the arbitral proceedings or not. So that power has been granted in the amended provisions of Section 9. So Section 9, court is only empowered till an arbitral tribunal is put into place. So in this scenario, in the legislation as we have, our 1996 Act as amended from till today we do not have any provision for emergency arbitration because we do have Section 9 with us, and Section 9 takes care at this stage prior to the coming into place of the arbitral tribunal. And once arbitral tribunal comes into picture, whatever interim measures have been taken, those interim measures can be tested by the arbitral tribunal, and whether those are to be continued or not is to be taken a final call by the arbitral tribunal. And then we do have a timeline, a very specific timeline, where the arbitral tribunal is to give its final decision. So in my view that once our parliament, our legislature has thought it prudent not to provide for it, I believe that such kind of is beyond the jurisdiction of the court to say that emergency arbitration is possible. Subject to Justice Bhalla.
No. Please don't say subject to me. Don't say subject to me.
But this is my opinion.
No, your opinion is, sorry, just a minute. Your opinion is absolutely right as far as you are concerned. But I would like to add that it is always the job of courts to push the envelope and never the job of a court to seal the envelope. This is my opinion of exercise of judicial power. So a court must, in a particular situation where Parliament may have forgotten to do it or Parliament may have refused to do it, must look for the power in that particular provision itself.
No,
and
that's
if
true.
The court is able to find it. Then
but once there is a conscious decision, here there is a conscious decision of the Parliament. Despite there being recommendation of the Law Commission, the Parliament opted not to legislate. So it's not just a mere slip.
You are absolutely right. But now, then let's go. Then we will have to go under Article 226 or 227, because you can't suppose somebody wants in this situation, in the present scenario of this matter. Where would he go? Okay, I'll open it up to, but then that will not be in this circumstance. Nah. I open it up to everybody. I don't know. I'm not so much of an expert on this part. Let's have somebody else's opinion. Two of us are trying to differ to add to the debate actually. Because somebody must play the devil's advocate, so I'm doing that today. Anybody else would like to weigh in, please?
Sapan is online. Sapan would like to comment.
That the question here right now, I can just frame it is that since Parliament refused to put that clause inside, would that be a prohibition for a court to extend the jurisdiction?
I would say they cannot judicially legislate. They can interpret a power which is existing. That's right. But they cannot do something which will amount to legislation by the judiciary. Judicial activism is all right, but judicial legislation is wrong, in my humble view.
That's why I said we want a third opinion now.
I think
if I may say so.
Yeah, please.
If I may say so, that we face similar problems of courts interference jurisdiction when the scope of issue, whether it's arbitrable or not, and whether arbitrator can be appointed under Section 16, was in issue like years ago. And that's when it was decided that courts cannot decide this because the provision is not allowing. It's the court to decide, and the arbitrator can decide on his power, and only a challenge can be made at a later stage. Even though it didn't sound logical that that it has to be challenged only under Section 34 at a later stage, and the whole thing can go turn around. But this is what was legislated to avoid court interference, and therefore it was upheld. In that German case, if I can recall, one of the German company cases. Definitely sometimes it's the provisions are not happily worded, but that's how
See, just sorry, can I interrupt? How long are we going to look at this happily worded argument? That's the unfortunate part. You see, on the one hand, we have a doctrine that says every word must be given meaning to. And then, unfortunately, you're right, absolutely right. Happily, it's not happily. Let's be very frank. Most of the Arbitration Act is very unhappily worded.
Correct.
Let's call a spade a spade.
Yes, and although that is a very practical view, that you can't hit the can and then somebody keeps rolling it.
So that's
also a very
my mistake.
Pragmatic.
It's not para 17. It's para 35. I'm sorry. That kick the can or part of the order is para 35.
Okay.
Mr. Jindal can now coin a new jurisprudence called the kick the can jurisprudence. Anybody?
I think we'll move on to the next case.
Please do.
That's all right. Okay, perfect. So the next case that we'll be looking at is Vidya Drolia versus Durga Trading Corporation. It's a decision of the Supreme Court, 3 judges bench. It was issued on the 14th December. This has also been in the limelight for a few weeks now because of 2 very important issues that it has decided. The first issue is the non-arbitrality and when the subject matter of the dispute is not capable of being resolved through arbitration. So essentially, it looks at what type of disputes can you be subject to arbitration. So for instance, commercial disputes, tenancy disputes, which I'll just come on to, real estate disputes, etc. And what cannot be subject to arbitration. So the court basically decided that, if there's a specific or express bar under specific legislation, then you can't have arbitration resolve those disputes. I'll come to that. And the other big issue that the Supreme Court decided is who decides the question of non-arbitrality. Is it the court looking at the dispute at the reference stage, or is it the arbitral tribunal, or what essentially, who looks at it and what are the factors and when do you look at it? So these are 2 broad issues, and I'll come to each of them in turn. But just very quickly on the historical or factual background, essentially, there is the decision of Himangi Enterprises versus Kamaljeet Singh Ahluwalia. And there were other decisions of the Supreme Court. There were all sort of two-judge benches. And I think there were conflicting opinions, which is why this case was essentially referred to a three-judge bench. So the law settled once and for all. In the Himangi Enterprises case, essentially what happened was that the Supreme Court said that tenancies governed by the Transfer of Property Act are triable by the civil court and not under arbitration. This, of course, has now been overruled. So coming to the first point on sort of what is arbitrable and what is not arbitrable, I think the key issue decided in this case was that tenancy disputes are arbitrable unless they are specifically governed by the rent legislation of that state. So I'm going to read out the main sort of paragraph, which I think is a good summary of what the Supreme Court held, and I'll read it. It says, the landlord-tenant disputes governed by the Transfer Property Act are arbitrable, as they're not actions in rem, but pertain to subordinate rights in personam that arise from rights in rem. Such actions normally would not affect third-party rights or have erga omnes effect or require centralized adjudication. An award passed deciding landlord-tenant disputes can be executed and enforced like a decree of the civil court. Landlord-tenant disputes do not relate to inalienable and sovereign functions of the state. The provisions of the Transfer Property Act do not expressly or by necessary implication bar arbitration. However, landlord-tenant disputes covered and governed by rent control legislation would not be arbitrable when specific court or forum has been given exclusive jurisdiction to apply and decide special rights and obligations. Such rights and obligations can only be adjudicated and enforced by the specified court or forum and not through arbitration. So if we basically look at what is arbitrable and what is not, the Supreme Court said that you look at 4 key factors. The first one is when the cause of action and subject matter of the dispute relates to action in rem that do not pertain to subordinate rights in personam that arise from rights in rem. So rights in rem are essentially, as you know, basically, the rights which you have against public at large, whereas rights in personam are inter se between parties, sort of private rights. So the court said that if the cause of action or the subject matter relates to a right in rem, then you cannot go to arbitration. But if it relates to a subordinate right in personam, which essentially originates from the right in rem, then that is fine and you can essentially go for arbitration. In the second one, the court said when cause of action and subject matter of the dispute affects third-party rights and requires centralized adjudication and mutual adjudication would not be appropriate and enforceable. So essentially similar when it affects third-party rights and requires centralized adjudication, then you cannot go for arbitration and you have to go to the civil court. The third is when cause of action and subject matter of the dispute relates to inalienable sovereign public interest function of the state. I think this is probably all clear and that's been the law for a very, very long time. And the last one is when the subject matter of the dispute is expressly or by necessary implication non-arbitrable as per mandatory statute. I think the fourth one is critical and has created a lot of case laws and controversies. The tenancy disputes, of course, relate to the fourth one. What the Supreme Court has also done is it's also looked at certain fraud cases and it's also looked at debt recovery tribunals and overturned cases, and we look at that. In relation to fraud, the Supreme Court said that it would be grossly irrational and completely wrong to mistrust and treat arbitration as flawed and inferior adjudication procedure. So I'm sure you're all aware how essentially if one party wants to avoid arbitration, they will say that this dispute involves complicated questions of fraud, which an arbitral tribunal cannot go to because it's again a right in rem. So the Supreme Court has basically clarified the position now and said that only if it's gross fraud and it's prima facie visible or apparent to the court that there is massive or gross fraud involved in this transaction or dispute, then the dispute is not arbitrable. But otherwise, it should be, because the courts cannot just completely mistrust arbitration as flawed or inferior. So essentially, if there are fraud allegations, prima facie, it would not be a bar from referring the matter to arbitration. It's also looked at the Debt Recovery Tribunal Act. Very interestingly, there was a Delhi High Court decision of the HDFC Bank with Sarpal Singh Bakshi. It was a 2012 decision which basically said that, courts, there are debt recovery tribunals, but banks can also go for arbitration if the banks opt to do so. The Supreme Court said you can't do that anymore because DRT is a special legislation, and by necessary implication, arbitration is essentially barred. So this decision has actually causing quite controversies within the financial sector because there are arbitration provisions between banks and the borrowers and the debtors, and some arbitration are even pending. But now you basically need to go to the Debt Recovery Tribunal. You can't possibly go to arbitration, private arbitration. So that was the first issue in terms of what is arbitrable and what is not arbitrable. I'll also deal with the second issue before I open it up for question and answers and look at what the panelists have to say. The second question was basically who decides what is arbitrable and when to decide. So the Supreme Court said there are 3 instances where that can be done. The first is the referral stage. So when an application is made under sections 8 or 11 of the Arbitration Act. The second is before the arbitral tribunal when the proceedings start. And lastly, if there is an award and it's being challenged, or there are annulment proceedings under section 34, is essentially where we can look to decide if the subject matter was arbitrable and not. I think the last 2 are probably well settled. The arbitral tribunal, of course, has jurisdiction to decide this. There is a ground under section 34 which says that if the underlying subject matter was not arbitrable, then that is the valid having the award annulled. I think the first one is basically the way of its time on. And that basically, so what the court said is that the referral stage, the court can only look at a very sort of prima facie view and consider the following. So the court basically laid down 5 key grounds on who has jurisdiction. And there are, of course, more procedural last 2 grounds. So if we just take them in turn, the first one is the court will look at the identity of the parties before the court and parties to the tribe arbitration agreement, whether the cause of action relates to an action in personam or in rem, like we discussed, whether the subject matter affects third parties, whether it relates to the inalienable sovereign or public interest functions of the state, and whether the subject matter is non-arbitrable by virtue of a statute. So like you can see, these 5, the first 5 essentially things that the court will look at is very similar to these 4 tests that we discussed. Basically, they're identical. So the court will look at them, but on a very, very prima facie view, and then decide whether the subject matter is arbitrable or not. And then, of course, there are the other mandatory provisions, which the court said it anyways has to look at, for instance, whether the agreement is in writing and whether the core contractual ingredients for an arbitration were fulfilled or not. So essentially, this is what the court held. It's been in the news for a while, this decision. I'm going to open it up to the experts. And if you have any questions, I think now is the time to sort of shout. I want to move from Mr. Jindal first. So sorry, I didn't introduce you early. Mr. Jindal is a senior advocate in the Punjab Haryana High Court. He also practices in Delhi and in Shimla High Court. Mr. Jindal, do you want to take us through very briefly a history of how there's been a controversy on whether tenancy disputes are arbitrable or not, and how it interplays with specific rent legislations across different states? There's also the draft sort of model tenancy law, which the government has recently passed. I think it was just 1 or 2 weeks ago. That, of course, provides for specific rent adjudication now, which has been taken away, I think, from the civil courts and given to sort of district magistrates. So can you share your views on this?
Yes. Firstly, I would just like to clarify on this issue. The model tenancy laws, which the parliament had passed in 2019, but this has not become law so far. It has not yet been published. And in any case, since it is a state subject, it would be open for the various states to either accept, adopt the same or not to adopt the same. It is not enforced upon the states. It is only a sort of a model legislation which has been provided by the parliament for the states to adopt or not to adopt. One. Secondly, this new legislation by the center, by the parliament, is more centric towards landlord. Earlier, the state legislations, they were granting a lot of protection to the tenants, which in fact is desirable now. Whatever the central government has done, it's the right kind of scenario. But as on today, they are not applicable in any of the state, because it is not yet been accepted by the various state legislation. So it's something still in the flux. Now, coming to the issue which we are having before us, Now, first of all, we must understand what is the meaning and concept of arbitrability. Now, as everybody knows that if two parties enter into an agreement, they can have an arbitration clause. Now, the issue is that supposingly somebody goes in Delhi, within the town of Delhi, and hires a commercial building. And in that, there is a lease deed, or there is an agreement between the lessor and the lessee. And in that, they provide for an arbitration clause. Well, question would be whether that arbitration clause can be invoked by any of the party in respect of eviction of the tenant. So that is the issue, whether such an arbitral agreement can be enforced. An arbitrator can be appointed so as to take away the protection which a tenant is enjoying under special laws, under special law of that particular urban area. The answer to that was given as back as in year 1981 in the judgment of the Supreme Court known as Natraj Studio Private Limited versus Navrang Studio and others. The court held that once the tenant enjoys a specific protection under this special act, then such dispute with regard to ejectment, well, one has to bifurcate. If it is with regard to arrears of rent or something like that, which does not have the consequences of passing ejectment order, then of course these things would be arbitrable. But the protection granted under a special law cannot be taken away by the parties ousting jurisdiction of that special tribunal or the special court created under the special legislation and opt for arbitration. So such will not be arbitrable. So this this judgment of Natraj Studio was unfortunately extended in Himangi Enterprise case to even those landlord-tenants dispute which are not even covered by these rent laws, these special laws, but it is covered by a general law which is known as Transfer of Property Act. So that part of the judgment in Himangi Enterprise has been overruled by the three judges bench in this Vidya Drolia's case. And it has been just 4 days later in Suresh Shah versus Hyped Technology, just 4 days later on 18th of December 2020, another three judges bench of the Honorable Supreme Court has in a very crisp manner applied the same law which has been laid down in Vidya Drolia's case, and held that when the property or when the particular building is not covered under the Rent Act, but it is governed by the Transfer of Property Act, then such a dispute is referable to the arbitrator, to the arbitral tribunal in accordance with the contract of the parties. So this is basically with regard to the landlord-tenant. In Vidya Drolia's case, the Honorable Supreme Court has basically, as you have elaborated, has dealt with two issues primarily: the arbitrability issue, firstly, and then second, the stage. At what stage this question of arbitrability and who can decide. So these are basically two issues which you have elaborated. And I just want to say fundamentally what they have said is that something which involves third-party rights, that cannot be made subject matter of arbitration unless it is the, as they have expression that rights in rem, but the subordinate part of it is in right in personam, then that can be arbitrable. So this is what you have rightly pointed out. And with regard to the second question, they say that by and large, the issue whether a particular dispute is arbitrable or not should be better left to the arbitral tribunal itself, because under section 16 of the Arbitration and Conciliation Act, the arbitral tribunal is best suited to decide its own jurisdiction. Unless on the face of it, prima facie it appears that the subject matter is not arbitrable. So in other words, the Supreme Court has used the expression dead wood. If the court referring the dispute to arbitrator founds that on the face of it patently this dispute is not arbitrable, then at the very commencement, at the very initial stage, that dead wood that should be cut down so that the efficiency of the arbitral tribunal is not decreased. So this is basically what is the law which has been laid down on these two questions of law.
Thank you. Mr. Dhalla, I don't know if you had anything else to add on to this.
See, I have read that judgment and I've read it twice and thrice. So if I could just, the Supreme Court refers to these judgments, the charge and all, but I think while applying it to this judgment, there seems to be, I'm an honest critic of it and not, I think there is an error. With Mr. Jindal, bear me out on that.
Certainly, Your Lordship.
No, don't say Lordship, please.
All right.
Please don't say that. See, once it is excluded from the Rent Act, then the property is no longer subject to the Rent Act. It goes to the Transfer of Property Act. Therefore, arbitration should apply. In fact, this is what should have been the judgment.
So that is what they have said. The Arbitration Act will apply.
Just see the relief.
No, there are two separate decisions. One by Justice Sanjeev Khanna, other by Justice N.B. Ramanna. Two separate judgments.
I'm, I think, reading the minority judgment.
No, they are concurring. They are concurring with each other, but they have given detailed judgment. It's a 90-page judgment. I was just wondering why the three judges can't sit together and render a common judgment.
I am talking about Himangi Enterprises.
No, Himangi has been overruled.
So therefore, Himangi has been overruled. And what have they said? I don't have that judgment with me, which you are referring to.
This is 2020 SCC online, SC 1018.
I'm sorry, I don't have that. Then I agree entirely with you. Once it goes to the Transfer of Property Act, it should be arbitrable.
It is. This is what precisely they have held.
And I can just add to the knowledge of all arbitrators over here that if you remember in the 1800s also there was an Arbitration Act. But the oldest enforceable arbitration is in the Punjab Land Revenue Act, Chapter 19, where the award by the collector is final. And it is not regarding, it's regarding all matters pertaining to land. So even the central government, if it had Farm Acts, it should have looked at that Land Revenue Act itself for adjudication. In the Farm Acts, there's a provision already.
But sorry to say, under the National Highway Act, the decisions of the commissioner acting as an arbitrator, they are one of the most horrible.
See, Jindal, those are human failings. They are not legal failings. If I am a judge, I may fail in my discharge of my duty as a judge. That doesn't mean that the law is wrong. It means that my understanding of the law is wrong, or my discharge of my jurisdiction is incorrect.
The disputes under the National Highway Act, they linger on more than anything else.
Absolutely right. But like I just said that, I can be a horrible judge, but that doesn't make the law wrong.
I don't think, are there any questions on this decision? I didn't get any question on the chat box. If anyone has it now, maybe a good time.
Sir, may I?
Yeah, please.
Sir, the way I understand this, I'm unable to find the rationale for holding that even decisions of arbitrability are best left to the arbitral tribunal. While on the one hand, I do understand that the principle of competence, if indeed that is the principle that applies, must be given to, and indeed Section 16 must must be sort of seen out to its full extent. While I understand that, practically speaking, this might be very detrimental to the parties, because let's take the unfortunate hypothetical case of an arbitration wherein there was a subject matter that was never arbitrable in the first place. However, the tribunal, say, has incorrectly determined it to be arbitrable, has rendered an award, has most importantly taken fees from the parties, and then it is never able to be enforced because the dispute matter was never arbitrable in the first place. So in light of that, I believe that this matter is best left to the courts. But since the courts have held that this is in fact the opposite, I am unable to understand the rationale.
May I answer, Vishwa, this query? Mr. Sajdev, you are right to some extent, but the logic behind this is that the court's interference should be minimal in where the two parties have agreed for arbitration. So, as you very rightly said, the expression competence, that goes to the root of the matter. Once there is an arbitration agreement, then only prima facie will be seen by the court. If the dispute is arbitrable, then the court will refer the parties to the arbitral tribunal, because otherwise it will entail so much of delay. The very idea, the very object and purpose of having an arbitration clause would be frustrated, because courts will take a lot of time. Then there would be appeal that this question is arbitrable or not. And if it is not prima facie, as the court have said, you have to see prima facie. And on the face of it, it looks like it is not arbitrable. Cut the dead wood out there. No reference to the arbitral tribunal, straightway rejected. But if it is a disputed, then it requires documents. It requires lot many things to determine whether a dispute is arbitrable or not. Then it is best left to the tribunal itself to rule on its own jurisdiction. And such a decision of the tribunal can later on, if ultimately an award has been passed, then a party who is aggrieved by such a decision, where they say dispute was not arbitrable, then the remedy has been provided under Section 34. The courts, you can again approach the court that, look here, the arbitral tribunal has wrongly assumed jurisdiction, and this is not an arbitrable dispute. So under Section 34, such an award can be set aside.
Thank you. I think I'll move on to the next case. So the next case we're looking at is again a Delhi High Court decision of November. So the Dholi Spintex Private Limited versus Louis Dreyfus Company India Private Limited, if I pronounced that correctly. Essentially, the factual background was very simple but very interesting. There were two companies, one based in Ahmedabad and one based in Delhi, which entered into a contract for sale of raw American cotton bales. Delivery was refused by the buyer because of delay in the delivery. And so the seller invoked the arbitration clause, which was clause 6 of their contract. The buyer, which of course is the respondent now, filed an anti-arbitration injunctive suit claiming that the arbitration clause was void. And why was that? Because Clause 6 stated that any arbitral disputes shall be resolved according to the rules of the International Cotton Association with venue as London. But I think essentially the seat was London. And Clause 7 said that the courts in Delhi have exclusive jurisdiction. So it was not a very well-drafted arbitration clause. And basically, there were various submissions made to the Delhi High Court by both parties. I have reproduced here if you want to read Clause 6 and Clause 7. But there were essentially two key issues that we're looking at. The first one is whether parties can choose the foreign system of law as the substantive law of the contract. And the second was whether the express designation of under Clause 7 provides exclusive jurisdiction of New Delhi, and that should basically be the seat of the arbitration. So both Clause 6 and Clause 7 are on the screen that you can see. Just coming to the first issue, basically what happened was, even though they were both Indian parties, the sale was on a high sea basis. So basically, Incoterms, I'm sure we're familiar with Incoterms, but basically the sale would have taken place on the high seas, and the transfer of ownership would have shifted on high seas. So the ownership of goods would have sort of passed in transit stage. This was the only sort of international factor in all of the transaction. Everything else was to be in India. So both parties were incorporated, located in India. The contract was executed in India. Payment was made in India. Contract was signed in India, etc. But based on this lone factor that the sale was on a high seal basis, the court basically said that it was fine for both parties to pick a foreign law, which was the English law, as the governing law of the contract. And the court basically relied on Reliance Industries and Another versus Union of India 2014 decision of the Supreme Court on the first issue. So the first issue is whether two Indian parties can pick a foreign law. And in the Reliance Industries case, the court had held that when there is a foreign element to an arbitration, three sets of law may apply. And we'll actually come to this in the knowledge session today itself in a few minutes when I talk you through three different laws and how parties can pick three different laws in a contract and what the importance of each law is. And on issue one, the Delhi High Court said, therefore, an arbitration agreement between the parties, being an agreement independent of the substantive contract and the parties, can choose a different governing law for the arbitration. Two Indian parties can choose a foreign law as the law governing arbitration. Further, there being clearly a foreign element to the agreement between the parties, the two Indian parties, that is, the plaintiff and the defendant, could have agreed to an international commercial arbitration governed by the laws of England. Hence, Clause 6 of the contract dated between the parties is not null and void. On the second issue, the court again relied upon a Supreme Court decision of 2019 in the BGS SGS Soma JV versus NHPC, where the parties have selected seat of the arbitration in the agreement, but such selection would not then amount to an exclusive jurisdiction clause. So on the second issue, the court basically harmonized Clause 6 and Clause 7 to say that the Clause 6 specifically states the venue was London, which was treated to be the seat of London. And even though Delhi courts had exclusive jurisdiction, Clause 7 would only be interpreted to mean that if arbitration clause was avoided by both parties or both parties agreed to completely delete or expunge the arbitration clause and have the dispute resolved by litigation, then essentially it would be the Delhi courts. And if I'll just read out the relevant paragraph and said, by agreeing to conduct the arbitration through international commercial arbitration, the parties have agreed that the seat of arbitration would be London and not Delhi. The parties have thus agreed to abide by the rules and bylaws of the ICA, which is the International Court and Association, which provides that the seat of arbitration is in London and the law of England and Wales shall apply to every arbitration and or appeal under the bylaws. Clause 7 entered into between the parties would be relevant if by an agreement both parties decide not to settle a dispute through arbitration, but by approaching the court of law, in which case the exclusive jurisdiction would be of the courts of New Delhi. So essentially what we've seen in this case is that two Indian parties can pick a foreign law to apply to their contract, can have their seat outside India as long as there is some element of internationality to that contract or to that transaction. So if there is any element of a cross-border nature, then that's fine. You can pick a foreign law, pick a foreign seat for your dispute to be resolved. So I just want to open it up to questions now to see what people think. I'm sure there are in-house lawyers, company secretaries from different businesses. Have you come across any situation before, or do you have contracts where which are basically domestic transaction or domestic contracts, but you've picked a foreign law? Is that something you would be willing to do? For instance, does it have any advantages over, say, an arbitration seated in Delhi governed by Indian laws? I think it'd be quite helpful or quite interesting to see what your views are. But if you have any questions on the decision, please do sort of shout. I'll also open it up to the panelists. Justice Bhalla, Mr. Jindal, Mrs. Mehrotra, did you have any thoughts on this decision? Do you think this is basically a door opening to domestic parties picking, say, Singapore as the seat and Singapore law as the governing law, or do you think this is just an exception, really? I think the panelists are probably having some technical issue. Okay, I think I'll just carry on with mediation and we can sort of discuss this with the panelists later. So those were the sort of three important decisions that I wanted to cover in arbitration. And now I'm going to come to mediation and online dispute resolution. So in mediation, in today's webinar, we're only going to cover two topics. One is the Singapore Convention, because it's sort of a leading update, or I guess a watershed moment in cross-border mediation. And the other is the Consumer Protection Act, which most businesses would be affected by. So what is the Singapore Convention? It's basically a convention similar to New York Convention for arbitration, where mediation settlements which have a cross-border element will be enforceable across different states that are parties to the Singapore Convention. So it came into force on the 12th of September 2020. It was open for signing in August 2019, so almost 13 months later, it's come into force. It only applies to cross-border enforcement, and it's mostly for commercial disputes. There are some express exclusions in the convention. For instance, if there is a mediation settlement which was approved by a court or is part of court proceedings, or if it is supposed to be a consent award and it's supposed to be enforceable as part of an arbitral award, then they will not be covered by the Singapore Convention. There are also subject matter exclusions for inheritance, employment law, and personal consumer disputes. If you have any questions on Singapore Convention, we can take them now. I'm also going to go to Ms. Mehrotra. She's an expert mediator handling disputes all over India. She is also on the panel of various mediation institutions, including Samadhan of the Delhi High Court and a lot of ODR startups like Webnyay. Ms. Mehrotra, what do you think? Is Singapore Convention a watershed moment for cross-border mediation settlements? And how do you think it will encourage mediation in India?
Hello, everybody. Singapore Convention, am I audible?
Yes, ma'am.
Okay. Singapore Convention basically dealing with the enforceability of the settlement agreements, and that deals only commercial dispute. It reads the scope of application. This convention applies to an agreement resulting from mediation and concluded in writing by parties to resolve a commercial dispute, which at the time of its conclusion is an international. Okay, so I would say that in India, we had mediations, as we were discussing before the webinar, that there were statutes where this settlement aspect was already there. Maybe the terminology per se mediation is not discussed. Even if we take Arbitration and Conciliation Act, Part 3, that is completely is dealing with mediation. Everything, though it is called conciliation, but the process which it describes, it's completely same as mediation, facilitative mediation. So it is nothing new here. The mediation mindset is always there, but the Singapore Convention, what I feel that it opens the door for the smooth enforceability. That is the main thing. Otherwise, under Arbitration and Conciliation Act, we always, like in Samadhan, what we do, pre-litigation mediation when it comes, not court referred. So we go for, we do the mediation under the Arbitration and Conciliation Act, that chapter 3, where it is conciliatory, the mediation process is mediation, but when we write the agreement between the parties, there we also we suggest, not, I mean, it is not a order like arbitrator or a judge, but in mediation, the parties, they come up, we as mediator or conciliator, we can suggest, and then when the agreement comes, it will be enforceable under ANC Act. So that thing is already there. But, and here in India, it is completely covering the entire, barring the criminal cases, the civil matters are totally covered under this, even in private mediation. The convention, Singapore Convention, is dealing with the international, like you said, the cross-border and the enforceability. These are the two aspects which is dealt with Singapore Convention, in my opinion. what I feel.
No, thank you, Ms. Mehta. I think that's quite helpful. I just want to also pick you on the Consumer Protection Act. So mediation has now become an option, whether it's mandatory or not, under the new Consumer Protection Act 2020.
So that I think Justice Bhalla can throw some light regarding the mandatoriness, because mediation per se, it is flexible because in fact we are, I feel that the flexibility which we as mediators enjoy as on date, even the parties, because there is no fixed rules. But we are thinking, if there is an Indian Mediation Act, which is in the pipeline, so will it take away the flexibility? That is a question. But the mandatoriness is only to the point that the parties can come, like if they, in Italy, what I know, I have come to know that they have been doing mandatory mediation before you approach a court. You cannot come to the court without exhausting that remedy. So I do not know whether in India that kind of a situation is emerging or not. But I think it is very, very good, because what I said, that whenever we talk that we will see you in court. But when this mindset will change slowly, then we will be eager to, okay, let us go and sit and discuss. So that is the thing I feel that mediation will bring in the dispute resolution. Sir can throw some light on it.
Yes, ma'am. I can, with Vishwan, with your liberty, can I just hijack this session a little?
No.
Sorry. Ma'am, you just said that to see you in court, nowadays it's see you in the media, not in the court anymore. So see you
Absolutely.
in 9 o'clock to 11 o'clock segment. That is where everybody is these days who matters.
Correct.
So, on that lighter note, we were doing an arbitration with two other honorable retired judges, and we had this issue before us where there was a mediation clause, and it said that before going to arbitration, parties will mediate, and in case mediation fails, only then will they go forward for arbitration. Now, the situation before us was the arbitration had commenced. Now, there were certain other claims which the claimant sought to raise by way of an amendment. The objection was taken that you have not gone for mediation for these claims, though those claims arose during arbitration. During arbitration. So we were faced with a quandary, and there is a Delhi High Court judgment. I'm sorry, I didn't know this question was coming. There is a Delhi High Court judgment which says that if there is a mediation clause, then amendment or no amendment, if it comes during this thing or no this thing, you will have to go for mediation. But then there's a flip side to that. There is a flip side to that. Now, presume we have arbitrated almost 80% of the matter. And then at that moment, parties again come back and say, now mediation has failed. So they go to the court, get a different set of arbitrators appointed.
So one question here, that can't we go in that during that arbitration process? Okay, you say that it has come up during the arbitration process. So there is provision in the ANC Act itself that we can always take to the conciliation route.
So if it fails, the question is, if it fails, then they have to go and get a new set of arbitrators appointed, because the Section 11 jurisdictional court may say, no, we are not sending it to the same arbitrators.
Okay.
Then what happens? So more confusion, more chaos.
More chaos and more,
more litigation for lawyers.
Yes. Because mediation is supposed to give a finality.
So what my request, I'm sorry, I just to conclude, my request to all arbitrators is, mediators, this maybe I may not understand mediation too much, is that please do not ask for a mediation act.
Yes.
Leave it to the mediators to decide what they want to do. Leave it to the corporates to have a mediation clause. Let at least, I mean, leave something at least through the discretion of the, to the
Correct.
good nature of people of the world at least. Leave something.
Yes.
The more you institutionalize, the more you make it into statutes, the more
it becomes rigid.
You put into cast iron, you know, it's just like medieval times, you're putting on armor and you can't get out of it and the fellow comes and chops your neck. So I personally feel we already have too many laws. So mediation, my request to you all, Mrs. Mehrotra, is that please don't push for that act.
I am not a votary for Indian Mediation Act at all. I think ANC Act is doing quite well.
And what we should suggest is, we should even try to take out a lot of the mediation from the court process into a private process. You know, arbitration is a private process. Only thing is it's become court centric.
Yes.
So this is my personal opinion. I don't know how many arbitrators will stone me in the evening. I don't know, but but this is my opinion. And I'm
no, it's absolutely
honest arbitrator.
I think going back to the slide we have. So specifically, I guess if you're looking at consumer disputes, disputes which,
in my opinion, absolutely it should be mandatory, but not by the act. It should be, if you see, every consumer protection is preceded by an act, by a contract, sorry. So people should be encouraged to put in a clause. Once you put it in the statute, then you have High Court judgment, Supreme Court judgment, 3 judges, 4 judges, 5 judges, and then eventually the government amends the act.
There is no end to it.
So I personally feel if you would have a clause there, and please somebody pick up that Delhi High Court judgment. It's a very good judgment on mediation. And I think that is the course we have to take for mediation.
Okay.
Hello, Vishwam?
Yes.
Oh,
yes.
I think I have to switch over to my phone because the battery in my iPad is showing low battery.
Yeah, that's fine, ma'am. I'm just going to move on to just give a very brief update, I guess, on ODR. It's more, I guess, like an introductory slide on what is ODR for our audience. We will probably have a detailed knowledge session on what is ODR and how it works in one of the webinars over the next few months. But essentially, there is no one definition of ODR. Niti Aayog has set up an expert committee on ODR under Justice A.K. Sikri. They had published that draft report in October last year. The final report is expected anytime now, maybe tomorrow, maybe in the next few weeks. But essentially what they define ODR is what I've said in paragraph 1, and I'm just going to read it. It's basically use of technology to resolve disputes. However, merely integration of technology in dispute resolution processes such as virtual scheduling is not ODR. The use of technology to actually resolve disputes such as video conferencing and digital circulation of files can constitute as ODR. ODR is also more than just EADR or E-alternative dispute resolution, but it can include the resolution of disputes through automated dispute resolution of AI/ML tools. So AI/ML here refers to artificial intelligence and machine learning. So this entire concept of ODR is basically based on Professor Richard Susskind's question whether courts is essentially a service or are courts a place. For those of you who don't know, Professor Richard Susskind is a professor in the University of Oxford. He's also a leading sort of philosopher / academician in the legal tech space. And he advises the Chief Justice of England and Wales on improving technology and improving courts through technology. So the committee has basically gone on to say that courts is a service, it's not a place. And the entire process of justice delivery can be a service, one that is based on accessible, formidable, intelligible, pervasive, robust, and designed with an outcome-oriented framework. I'm not going to open up for the panelists on this one because we're going to have a detailed session of ODR in the next few months. But if there are any questions on what is ODR from the audience, please let me know. We're also obviously most welcome to look at the expert committee report on ODR.
Can the panelists also ask a question on this one?
Please.
So do we have any law in India on AI? Because I think before we implement that, part of ODR, I've been hearing all this for a long time, that AI is going to be used, AI tools will be used for courts. So do we have a law on AI in India?
We have a draft policy by Niti Aayog. Again, that draft policy was released, I think it was only November or December last year. Comments were invited from the public. And I think once comments are in, I don't know when the last it was, but essentially then Niti Aayog will come up with a final policy on AI. And then it's going to be sent to the government to sort of put it in laws, etc.
Thank you. Now I'm prohibited from asking any questions.
No, thank you, Justice Balla. So I think that concludes the first section of our webinar, which is basically the update section. The next section is essentially, like I said, the knowledge or the sort of learning session for our audience. And today's topic is essentially designing a jurisdiction clause in your contract. Now, I've used the term designing rather than drafting because I think jurisdiction clauses are quite important. And if you're looking at an ADR or an ODR track, I think this is predominantly the key clause which any litigating lawyer would look at before he probably looks at any other clause in the contract. So as part of jurisdiction clauses, there are two essential clauses which every commercial contract will have. So for the purpose of this sort of session, we're only looking at commercial contracts. Again, there could be a completely domestic transaction, but we've seen even in domestic transaction, if there's any element of cross-border nature, then you can basically have a jurisdiction clause and a governing law clause for a foreign law and a foreign seated arbitration of the Delhi High Court decision that we discussed today. But I guess predominantly it mostly would apply to cross-border disputes or domestic disputes where you want to have exclusive jurisdiction conferred upon any court. So there are two clauses we're looking at: jurisdiction clauses and governing law clauses. For jurisdiction clauses, of course, generally parties would confer, either go for litigation. So, and for litigation, they would say, any dispute from this contract will exclusively be referred to, say, the courts in New Delhi or in Bangalore. A lot of the terms and conditions, if you actually read for e-commerce websites or your daily apps you use, say Bangalore is the exclusive. So, or mostly if you're booking a ride through Ola, for instance, if you're buying something off Flipkart or Amazon, most of the terms and conditions say that any disputes would basically be exclusively referred to, say, the courts in Bangalore. So that is essentially an example of an exclusive jurisdiction litigation clause in favor of courts in Bangalore. There are also multi-tiered disputes where you have to go in first for negotiation, then mediation, then conciliation. They're not that common. They're quite common in specific sectors. For instance, construction sector, it is very, very common to have a very high-level multi-tiered clause which provides for negotiation in 30 days and mediation for 30 days, and then you finally go into arbitration. You can also have adjudication, for instance. So we will not be looking at those specific multi-tiered processes today, which are predominant in construction or in energy sectors. But generally, I think looking at commercial contracts here. So in litigation, I guess there are two broad categories of what you can have. Exclusive jurisdiction clauses. This basically means that, the parties agree that only the courts of Delhi will have jurisdiction, or only the courts in Bangalore or Chandigarh or any city will have jurisdiction. So if there's any dispute under the contract, basically the parties agree that, you just have to file a case there, and then that's the end of the story. Internationally, the asymmetric jurisdiction clauses are quite popular. They're very, very popular in the financial space. What this basically means is that one party will have the option to file a case in multiple courts, whereas the other party will have the option to file in only one court, for instance. So to give you an example, say SBI loans some money to an industry, to a company called X. So in an asymmetric jurisdiction clause, SBI will have the option to file a case against X in a number of jurisdictions or essentially anywhere it wants. Whereas if X wants to file a case against SBI, it can only do so, say, in the courts of New Delhi. So that is an asymmetric jurisdiction clauses. It's been around for, I guess, almost 2 decades now. Different countries have different laws on it. So if you're looking at English law, if you're looking at Singapore law, asymmetric jurisdiction clauses are completely fine, they're legal. But in a lot of other jurisdictions, courts have said that asymmetric jurisdiction clauses are not valid because they're not balanced on the basis of equity. So if you're looking at similar jurisdictions like the UAE or China or Russia, they don't think asymmetric jurisdiction clauses are actually valid. So basically, you cannot hold the borrower to an exclusive jurisdiction clause within the asymmetric jurisdiction clauses. If there are any questions on that, please unmute yourself and ask, or put it in the chat box. What I'm going to move on to now is drafting or designing an arbitration clause. So what we're looking at here is just arbitration clause. We're not looking at a multi-tiered arbitration mediation clause, though I will show you an example in the clause which is used in the future group versus alliance arbitration that we discussed in the beginning of this webinar. In arbitration, generally, there are multiple elements. A, what will be resolved by arbitration under the contract, whether the arbitration is institutional or ad hoc, what arbitration rules will govern the arbitration, what is the seat or legal place of the arbitration, how many arbitrators will be there, and the language of the arbitration. And I'll take each of them clause by clause in a model clause. So for instance, this is how a typical arbitration clause would look like. Of course, there are like hundreds of examples, but this is a model clause for which the parties, for instance, can use. And I'm going to go word by word very slowly here. If there are any questions on this, please ask, or if the panelists have anything, they can jump in.
Yes, can I just be excused?
Of course, please.
I got to take your.
No.
I've got just something else lined up. So please.
Thank you.
I'm sorry, I'm leaving before time.
No. Thank you so much, Mr.
It was wonderful listening to my own voice, actually.
Thank you.
Sorry. Okay, bye. See you guys. Everybody, thank you very much.
Thank you.
Okay. Thank you, sir. Thank you.
Bye.
So I'll just start reading out and then we can sort of discuss it. So any dispute or claim arising out of or in connection with this contract. So basically the first half pretty much would cover any claim or dispute that which arises out of the contract. For the purposes of clarity, a lot of parties also want to mention that it includes any question relating to the existence, validity, or termination of the contract. Some clauses that I've seen also mention about torts. So they do say any dispute, claim, or tortious actions arising out of or in connection with this contract. So I guess if you want to cover that expressly, you could, but I guess most clauses, or at least a good arbitration clause, would not cover that. Then it says, shall be referred to and finally resolved by arbitration under the Webnyay arbitration rules. So of course, Webnyay is acting as an arbitration institution here, but it could be any other institution you want to pick. So if you want to put SIAC, Singapore International Arbitration Center, if you want to put MIAC, Mumbai International Arbitration Center, there are of course various domestic arbitration centers. There's one attached to the Delhi High Court. There's one attached to the Nani Palkiwala Arbitration Center attached to Chennai Madras High Court. So this is where you would basically put the name of their rules. And then you basically say which rules are deemed to be incorporated by reference into the clause. So the first bullet point that you see here, basically what we've done is we basically said that, every dispute from this contract, including its validity, termination, etc., shall be resolved by arbitration under the Webnyay arbitration rules. And those rules form part of the contract under this clause. The second bullet point is where we talk about a little more about how that arbitration would run. So for instance, would it comprise of 1 or 3 arbitrators? So you cannot have 2 arbitrators because the Arbitration Conciliation Act doesn't allow you to have 2 arbitrators. So it has to be either 1 or 3. And then those arbitrators are to be appointed in accordance with the rules. There are a lot of arbitration clauses where the parties actually say how arbitrators will be appointed. So the claimant will appoint 1, the respondent will appoint 1, and the third will be mutually appointed by the arbitrators that both sides pick, or the third will mutually be appointed by both parties themselves, or the third will be appointed by the institution, for instance. So of course, this is an institutional arbitration clause, but you can also have ad hoc arbitration clauses. So the difference between institutional and ad hoc, for instance, is that if you go for institutional, there is an institution which oversees the entire arbitration. But for ad hoc, the parties have to do it themselves. And if it's an ad hoc arbitration, you can have the unset trial model law apply, for instance. So basically, this is how you would basically decide how many arbitrators will be there and who would appoint them. Then you want to decide what is the seat of the arbitration. Again, if it's an international arbitration, it should be both city and country. If it's just a domestic arbitration, you don't need to say India. It could just be Delhi or Chandigarh or Bangalore or Mumbai. And then the final sentence, you need to pick the language of the arbitration, just so it's agreed upfront in advance, and there's no controversy later. And the last one is actually the governing law of the contract. I'll come to the governing law clause later, but essentially, substantive laws of India will apply, for instance. So this is a model clause which you can use in your contracts. If you want, you can just basically sort of copy paste it and use in your contracts based on certain modifications that you'll have to make. I'm also going to look at a submission clause, or a clause if the parties want to submit a dispute to arbitration, which dispute is already arisen. So for instance, if you have a contract which does not have an arbitration clause, or which has an arbitration clause, but it's terribly drafted and you basically don't know what to do, what you can do. Sorry, does someone have a question? Okay. If you have an agreement without an arbitration clause or a terribly drafted arbitration clause with no idea what to do, you can enter into a new agreement, both parties, saying instead of going to court, we will go to arbitration, and you can have an arbitration clause on these lines. So the second and third paragraphs are actually very similar to the one we saw in the earlier slide. But the first one is slightly different because it says a dispute has already arisen between the parties, and then you can put the details. And then you can basically say the parties hereby agree that the dispute shall be referred to and finally resolved by arbitration under the Webnyay arbitration rules, or whatever institution you want to pick, or ad hoc if you want to pick ad hoc. So again, this clause works if there is an existing dispute you want to resolve by arbitration, you can just copy paste it into an agreement, and you're good to go, really. So this is an example of a clause used in the Future Group versus Amazon arbitration, the first case that we discussed in today's webinar. It's quite long, complicated. You can see it's run in sort of 3 slides, and the font size isn't that great, but essentially what these 3 slides say is essentially what I covered in sort of 1 slide. So I think it's always important that you draft an arbitration clause quite succinctly and quite clearly. It doesn't have to run into pages and pages and basically convey very little. But here's an example, for instance, if you want to read a clause which was used in a contract. So if you look at the governing law clause here, basically all they're saying is that the laws of India apply. They're not really adding much more than that. If you look at arbitration clause, this is an example of a multi-tier arbitration clause. So for instance, they start similar to how we started, but then they say that, there will be negotiations between both parties. And they say that there is a time period of 30 days for negotiation. So if both parties can't resolve within 30 days, then they said, we'll go to SIAC. The SIAC arbitration rule will apply, and the arbitration will be seated in New Delhi. So this is an example of the clause. The seat was basically a new clause where it says just New Delhi will be the seat, for instance. Okay, so that was the arbitration and jurisdiction clause. I'm guessing there are no questions because I haven't heard from anybody.
Oh, there is a question I have.
Yes.
In case of an online dispute resolution mechanism, how seat of arbitral tribunal would be relevant?
So that's a very good question. So the seat will basically have obviously various importance under the arbitration law. Essentially, in an ODR mechanism, the seat will remain as a seat, but the parties can access or participate in the proceedings from pretty much wherever they want to be, whether in India or outside. But the seat is relevant from arbitration more generally, because if there is an award issued in ODR and the one party wants to challenge the award, then obviously he will have to challenge the award. in the seat of the arbitration. So if the seat was New Delhi, for instance, the award will only be challenged in the courts of Delhi then. You cannot challenge it elsewhere because the seat determines where you can challenge an award under Section 34. Similarly, it's in a cross-border dispute under ODR, it's relevant for how your arbitration agreement will be interpreted, whether it's valid or not, or whether it's arbitrable or not, etc. So the seat, I guess, will still maintain or still have the same relevance that it would have whether it's ODR or non-ODR. The only difference in ODR is that you can be based anywhere and conduct your arbitration proceedings smoothly and quite inexpensively. So I'm going to, I think you're on 2 devices, which is why there's echo. Do you want to log off from one device and?
Okay.
There's still echo, I think. Yeah.
Now, I would like to ask one question that in the Amazon case, they have already said that there is a 30 days period for negotiation. Correct? In that arbitration clause. Hello?
Yes.
Am I audible?
Yes,
Hello?
yes. Yes, we can hear you.
So in that case, it is as good as mediation. That 30 days period negotiation, it is mediation. Because facilitative negotiation is mediation. Instead of both parties negotiate, I mean, this is where Justice Valla, he said quite correctly that the flexibility, which I also feel, the flexibility of mediation must be maintained. Otherwise, if there is a mediation act, then there are all these, watertight rules and regulations. You have to do this, you have to put in. But in this, that 30 days negotiation, that line is there. So you can always go in for facilitative negotiation, if possible. I mean, not in this case, but in any case, that's what I'm saying.
Yes, of course, yeah. I mean, I guess the only difference here is that because it says negotiation and not mediation, the parties could have done it without any independent mediator or without any person being involved.
But there is no harm in doing a facilitative negotiation also. Even in ANC Act, it is provided that at any point of time, they can go in for, the discussion and settlement.
Of course.
If the parties so want.
Of course, yeah.
What I feel, Madam Sangeeta, is that instead of, because once their dispute, as we were discussing in the very beginning of this webinar, the dispute is fundamentally when the two parties have a difference of opinion. Yes. In my view, it was always be better. It was always the most imperative to have an independent person who is not related to any of the party, even to act as a mediator.
It has to be neutral.
Neutral and impartial.
And independent.
Yes, if that mediator is related to any of the party or is under the employment of any of the party, naturally the other party will not have faith in that mediator. So it has to be impartial, totally independent, and should act in a transparent manner so that none of the parties have any grouse or even a shadow of doubt.
Without any prejudice.
Without any
and confidential. Total confidentiality has to be maintained.
Of course, confidentiality has to be the utmost. That's true.
The thumb rule is mediation is confidential.
Other than the two, it's something I would say a lesser arbitrator.
Yes. There you cannot order, like, you cannot pass an award or something like that. You
just have to do a patch-up kind of situation.
Creating options, exploring options from both the parties, going into the underlying interest, why the dispute is there. What is the dispute? No, what is the dispute? It is there before us. Why it happens? That is the skill of the mediator to go into the we are seeing the tip of the iceberg, but you have to go deep down. And how? You have to communicate with the parties separately. Then only the things will come out.
In the lighter vein, I can add, it's like an Ayurveda system of medicine rather than allopathy.
Yes, yes. Correct.
Thank you for that. I think I'll move on to the governing law clause now. So the law is pretty clear on what can and cannot the parties agree on in terms of governing law. So there are essentially three laws that parties can pick in a contract. The first one is that the parties choose the governing law to the arbitration agreement, which is procedural in nature. The second is the proper law of the conduct of the arbitration, again, procedural in nature. And the third is the most substantive law in terms of what is the governing law to that contract. So I'll give you an example as well as how and what rights they affect. So the first one, which is the parties choose the governing law to the arbitration agreement, basically is the proper law of the arbitration agreement, and that governs the validity of the arbitration agreement. It determines the question whether a dispute lies within the scope of the arbitration agreement, the validity of the notice of the arbitration, the constitution of the tribunal, the question whether an award lies within the jurisdiction of the arbitrator, the formal validity of the award, the question whether the parties have been discharged from any obligation to arbitrate future disputes. So essentially so you can see that the governing law to the arbitration agreement is quite relevant from an arbitration agreement perspective or an arbitration clause perspective. The second one, which is the proper law of the contract of the arbitration, also popularly known as Curie law or the institutional rule, is basically the manner in which the reference of the arbitration will be conducted. So this will, for instance, regulate the procedural powers and duties of the arbitrator, questions of evidence, the determination of proper law of the contract, etc. And the last one is actually the more substantive law that the parties choose, and it governs substantive rights, which is basically what parties, whether the parties have been discharged under the contract, whether the determination was valid, what are your rights, obligations, liabilities under the contract. So essentially, the law which will govern the entire contract except for the arbitration agreement. So these are the sort of three different laws that the parties can pick. Just to give you an example, for instance, if we come back to this clause, can someone tell me what will be the first law here? So what will be the governing law to the arbitration agreement in this clause? Does anyone want to unmute and say from the audience? Okay. So the governing law of the arbitration will be Indian law here because they haven't prescribed any. The last bullet point says the governing law of the contract shall be substantive laws of India. So the governing law of India, substantive laws of India, is both number one, the governing law of the arbitration agreement, as well as the governing law of the contract here, because you can see the seat is in India, if it is in India. And the substantive law is also India. Of course, if the seat was, say, Singapore here, then the law applicable to the arbitration agreement would be Singapore law, not Indian law. The second law, which is the Curie law, the conduct of the arbitration, is the institutional rules here. So quite clearly, that would be the Webnyay arbitration rules in this model clause. In the in the future Amazon arbitration, it was SEAC rules, which was the Curie law, for instance. So these are basically three different laws, governing laws that parties pick in a contract. Which law applies to which part of the contract is quite critical, quite relevant. And what those laws do is essentially decide these questions, which you can see on the slide and we've discussed. So I think that's all for today's webinar. If you need to get in touch with me, my email ID is on the screen. If you want access to the slides, I'll store the slides in a cloud and I can give you access. You'll have to drop me an email for that. If there are any questions and answers which we haven't covered, we can cover them now. Of course, as Chaitanya mentioned in the beginning, we'll have a webinar each month. So and we have a few planned as well, but if there's any specific update or knowledge session that you really want for the future, please send me a line with your ideas. And if you also want any introduction to the panelists, or if you want introduction to Mr. Puneet Jindal or Justice Bhalla or Ms. Mehrotra, drop me an email and I'll put you in touch with them if you want to discuss any legal queries. What I'll do is I'll maybe drop in my email in the chat box here as well. If there are no questions, I guess I'll hand over back to Chaitanya to close the session.
Thank you, sir. It was really an enlightening session. And we thank all the experts for discussing each and every case law and each and every concept very succinctly and in a very detailed manner, for bringing a clear picture for our participants. So participants, this brings us to the end of session 1 of our initiative of our ADR Live Law channel. In the next session, we'll meet you again in the last Friday of the February month. And we look forward to serve you in our future sessions as well. So for any queries and for subscribing to our channels, for knowing more about our initiative, I'll just post the link and the WhatsApp number on which you can contact us. So goodbye, take care, stay home and stay safe. Thank you.
Thank you, everybody.
Thank you, Chaitanya. Thank you, everybody.
Thank you.
Thank you. Thank you, Vishwam. Thank you, Jindal sir.
Thank you, ma'am. Thank you, Vishwam.
And thanks all the participants.